Welcome to the Florida Divorce Podcast, your source for the information you need to successfully get through your divorce and into the next exciting chapter of life. Now, here's your host, Attorney Scott Kalish.
Hey, my name is Scott Kalish, and I am a divorce and family law attorney here in South Florida. Today, I have a special episode to share with you. I actually had the opportunity to interview a prominent family law mediator here in South Florida, Matthew Brickman. He's probably one of the most passionate people I've ever worked with in the family law space, and I really enjoyed hearing his story and also hearing his perspective on mediation. If you're going through the divorce process, you're definitely going to find this episode very, very helpful. I hope you enjoy it.
Matt, thank you so much for agreeing to be on the show today.
Yeah, great, Scott. Glad to be here.
Awesome. Why don't you tell everybody, how long have you been mediating?
This year will be 17 years.
17 years. Wow, that's a really, really long time. And are you primarily mediating only family law cases throughout that 17 years, or did you kind of venture off into different areas as well?
Yeah. So you know what, Scott? Let's back up. It's been 17 years, but let's back up because I haven't always done family. So I actually got into mediation because I got divorced. And so, sort of life put me into this situation. I got divorced and judge ordered us to mediation. And I had a great attorney, great mediator that both inspired me. And I'm sitting in mediation going, this is the coolest process in the world. I could do this. But at the time, I had a cosmetology license, a driver's license, and I had a high school diploma.
And this is what year?
This is 2003 or 2004.
2003, 2004, you're going through a divorce.
Prior
to this,
okay.
Go ahead. Sorry.
Got divorced in 2000. Was it 2000? Yeah, somewhere around there. Somewhere around 2000, 2001, 2002. I don't even remember now. It's been so long. Actually, no, let's see. It's 2024. So this recording's in 24. I've been divorced 20 years. So 2004 or so. So yeah.
2004.
I don't know. Anyway, I don't even know.
A lot of time, yeah.
A lot of time.
But so you go through a divorce, then you come back, post-judgment?
Well, okay. So my ex and I fought for 12 years post-judgment. So we got divorced. And then after in 12 years, it was 43 motions for contempt enforcement. My docket entry, Scott, you would know. So let me ask you this from an attorney standpoint. Sure. What's the longest docket entry, like the most entries that you've encountered in your practice?
Okay. So this is a great question, right? Especially when people call me, right? One of the big red flags when people call me for post-judgment work to hire me post-judgment is I'll look at the docket. And depending upon how old the case is, I would say if we're getting into like the 200 or 300s, something's wrong. I think the very longest I've seen as like consulting with a potential client, probably just over 1,000. And obviously I don't want anything to do with a case like that because it's just too much to go back and like review what happened and understand how they got here. It's very hard to pick up a case at docket entry 1,000 and confidently represent them without knowing anything, right?
But normally, like average is what?
Average what? Post-judgment? I would say a couple hundred, maybe 150.
Yeah, so mine was 520. High litigation.
Yeah. Oh, very high. And anything over a few hundred is like you're getting into like just nonstop nonsense.
Yeah.
Every month, every week, I'm sure something's being filed.
Yeah, So 520 docket entries is what we finally settled on, 12 years. But sometime in the beginning, after a number of motions for contempt, the judge was tired of seeing my ex and I. And that was when the judge ordered us to mediation. I had never heard of mediation, didn't know what it was, had no clue, except my attorney says, Matthew, you need to show up at this office on this day at this time for mediation. So my ex and I showed up and we're sitting in the lobby. We're on the opposite sides of the lobby with our attorneys. And Scott, it felt the best way I could. And I've shared this with people and people have they've nodded their head. They can identify with that. It felt like the four of us if you can just put this in your mind's eye, it felt like the four of us were encapsulated in a bowl of Jell-O. You could feel the tension in the air, and it was so tight that you could actually cut it with a knife. Like, it was so tense. Just that we weren't even negotiating or talking. We're just sitting there waiting. But it was so intense. And so the mediator brings us in, and she was a mediator attorney.
Okay.
And she brought us in. We all sat around a table together. And my ex opened up her mouth, and I looked across the table, liar, liar. And the mediator's like, settle down, settle down. And what
was the issue that you guys were, do you remember the issue that you guys were mediating?
It was the same issue. Yeah, it was the same issue. So we we had a very amicable divorce. We did it ourselves, no attorneys, no mediator, no nothing. Yeah. And it was very fast. We filed our papers it was a Monday. It was the day after Mother's Day, and we were divorced 3 days before Father's Day. That's pretty fast.
Okay. Yeah, no, pretty fast for sure.
Now,
what county?
Martin County.
Okay.
Now, then a year later, it started a 12-year war when then she gave me the kids. She then wasn't showing up for time sharing, wasn't paying child support. And I was simply like, look, if the shoe was on the other foot, you'd throw me in jail, forget about me 6 feet under. So you know what? You need to comply. Yeah. You need to pay. You need to show up just like, what's good for the goose is good for the gander. Well, not so much. And so when we started our war, she was $500. And so child support was $500 a month for 2 kids. And so we started out, she was 1 payment behind, and I filed a motion for contempt because I was told, and I'm sure you tell clients this as well, and I tell people as a mediator, look, the court is not micromanaging. They're not looking at your case. It's only if someone's not complying, then you tell the court and then they'll step in. But they don't know automatically that, someone's not complying. So I did what I was like, she's not complying. I'll tell the court. I filed a motion for contempt. He owed me $500. When we were done, it was $33,000. And Scott, what it was 43 motions for contempt enforcement for failure to pay child support and exercise time sharing. Could not get the court to enforce its own rules on her. They always gave her a pass. They didn't hold us to the same standard.
Why do you think that was?
I don't know. You'd have to ask all the magistrates and all the judges we had over the 12 years. I don't know why they did not hold her to the same standard. But they didn't. And I was relentless, and I was not backing down. But look, in hindsight, now here we are 20 years post-divorce, and we get along great.
That's awesome.
And her new kids and I actually get along. They love me. I like them. They're a lot of fun. Her husband has called me asking for advice. She even asked me 2 years ago to actually mediate between her and my adult son because they were having issues. And I'm like, are you insane? Like, I fought with you for 12 years. You're my ex-wife, and you want me to negotiate between you and my own flesh and blood? Challenge accepted. Game on. And actually did it, was able to stay neutral and help both of them. And they've had peace ever since. So
that's awesome.
So post-judgment, fine. And I got no regrets, Scott, because it all led me to my calling. Plus, I know things that you don't learn in a book. I lived them.
Absolutely. No, for sure. And that's the best way to just learn this process, right? It's just kind of by being in it every single day.
Yeah. So the judge, I don't remember how many contempts in, the judge ordered us to mediation. And that's where I first encountered mediation, was fell in love with it. But of course, I didn't have any licenses. I didn't have any degrees. And so I actually went to school specifically to get all of my degrees for mediation. And so a lot of times people will go to college, they'll get a degree, and then they never use it. Mine, actually, I use every single day because I'm like, okay, this is what I want to do. What do I need in order to do that? And so all of my degrees were for exactly this. So when I finally started doing mediation, I really wanted to do family because that's my inspiration because of my own stuff. But I was not about to jump into family with no understanding of mediation whatsoever. So I said, you know what? Let me figure out this whole mediation thing when there's not a whole lot on the table to risk that if I screw things up as a mediator, I haven't ruined your family, you lost your house, your retirement, all of that stuff, right?
Yeah.
So my first certification was actually in 2007. I got certified as a county mediator. So I was doing small claims court. I'm like, how bad could I be messing up under $15,000, right?
Right.
And for most of that, Scott, what I've learned since then, that's actually more difficult than family.
Why do you say that?
Because, so when you're fighting over, for example, I'll never forget, it was a roommate situation gone bad. It was two women were in a relationship together. They broke up, but they were roommates. And now one of them had moved out, didn't pay their rent. And so the other one had to cover it. So then they filed in small claims court. Now, of course, it's emotional, but here's the deal. They spent $300 to open up the case, right? At the time.
Yep.
You know what they were suing for? $500.
Yeah.
And it was principal. And here was the weird thing is as a mediator, I'm like, okay, so you're looking for your $500 plus your filing fee. And they said, no, I don't need the filing fee. I just want my $500. And you're like, what? It was pure principal. Yeah. And you know what? They weren't. And so, and a lot of times too, in small claims court, it is the principal. They will die on the Hill. And it's very emotional because there's a declared winner, declared loser. Whereas like in family, everybody's getting something. It's equitable distribution, right? But when there's nothing except one thing to negotiate and someone gets it and someone doesn't, that actually is it's more difficult. So the other thing too was I figured, let me cut my teeth with the safety net of working with the court in the courthouse.
How long did you do that for?
Well, I did that from 2007 until 2008 when I got certified for family. So about a year. And now with that, it was difficult because nobody, like I was living in Jupiter at the time. I was living in Palm Beach County, but they didn't need any mediators in West Palm Beach. They didn't need any in Gardens. They didn't need any in Martin County. They didn't need any even down at the main courthouse or South County. I actually drove all the way up to St. Lucie County. And you know what they were paying, Scott?
Fort Pierce. What's that?
They were paying $10 per case. I was spending more in gas than what I was actually making. But you know what? I was there for the experience, to learn the process. I wasn't there to make money. I was there going, I want to learn this process because I knew what my eventual goal was. And I didn't want, again, to make some pretty serious mistakes. So then I got certified as a family mediator in 2008. And so in 2008, I was starting here and there. I'll tell you, in 2008, I had 15 family law cases. A year, the entire year. That's all I had. I had 15. Wow. Now, I've always told everybody that wants to be a mediator, do not quit your day job. Do not quit your day job, because this is not something that you can just be like, okay, I'm just going to be a mediator. No, this is something that has to build, and it's going to take time. Like I'm sure for you as an attorney, it takes time to build your clientele, build your reputation.
It does.
Right?
It does. But the only little difference I would say is there's so many people out there needing family law help. Yeah. And if you just hang your shingle and you say, hey, I'm a family lawyer, and you lower your prices a little bit, you'll have a flood of business. But I think it's a little bit different for mediators because not everyone wants to just hire a mediator pro se. Oh. Right. And as attorneys, it takes a lot. So there's got to be a lot of trust for me to kind of send the other attorney a list of mediators and for you to be on that list. Yeah. You're a classic example of it. I think a couple of years ago, someone said, Matthew Brickman, at that time, I had never heard of you. And I was very reluctant. And the other attorney swore by you. She's like, oh my God, you've never used them. You have to use them. And she basically made the case to me, and I said, oh my God, I have to try them. And it was a nightmare case. And it was one of those cases where I just really didn't like the client just because he didn't want to have his kids and didn't want to pay child support. So it was just like a nightmare case. And I'm like, there's just no way this is going to settle. There was a trial on the horizon in like 3 months. And I'm like, there's just no way this is going to settle. I'm just going to have to take this one for the team, get it, go to mediation. It's not going to settle, go to trial and just be done. And all the while he's complaining. He doesn't really want to see his kids, doesn't want to pay child support, just a complete nightmare. And then I meet you and you settle it. And I'm just like, holy crap. Like, who is this guy? And the way that you went about it was just so flawless. I mean, and the way how you got him to settle, it was all you, I helped, but you handled them just beautifully, and we settled that case. And then ever since then, I mean, you're on my list of mediators for every single time that I send one to opposing counsel.
Well, and Scott, you make an interesting point there. So yeah, I mean, especially starting out, and I'll tell you, most mediators that I have met through the years, they're retired teachers, they're retired therapists, they're retired social workers, they're retired attorneys or retired judges. And if you're not if you're not an attorney or a judge, you have no place doing pro se mediation because you don't know the law.
You're right. And I was going to ask you about that, right? So like, how often are they, as a pro se, I mean, are you giving them an education? Because you really can't advocate. You can't take a position with either one of them.
Correct.
Going through a pro se mediation, right?
Correct. So with a pro se, and so, I mean, as of last year, and we'll go back to 2009 in a second. But
before we go there, though, can you just explain what a pro se mediation is? So I'm sure there's some people out there that don't know what that is.
So pro se mediation means that two people, say husband and wife or a father and mother, because it can be a divorce or it can be a paternity, they're going to go through the process, but they want to do it themselves. So it's a DIY, and they do not want to engage an attorney. So they want to do it, but they can't do it themselves because they don't know how to do it. Plus, you got to go through mediation. So they will then contact me or a mediator, and then I will then take them through the process. But you're absolutely right. I am not representing or advocating for the mom, the dad, the husband, or the wife. I am there as a neutral, helping both of them get through the process. So what I do, I'm there, and in all mediations, I'm there for 3 jobs. My job is, number 1, to provide information and creative suggestions. That's job 1. Job 2 is to help people negotiate. And job 3 is to help get through paperwork. Okay. So with a pro se mediation, for example, I can't say, hey, Bob, hey, Jill, here's what the law says. And here, Bob, you need to do this, or Jill, you need to do this. I can't do that. But what I can do, and I do this a lot of times, even in a mediation, where I'm like, okay, let's look at the statute. Let's see what the law says. Okay. Here's what the law says regarding, say, for example, alimony. You first have to get through need and ability, and then let's look at all the factors. Okay, so here's the information. You guys decide what you want to do with that information. I'm not telling you what you should or should not do. Let's look at the statute for time sharing and child support. Okay, well, time sharing, there's a rebuttable presumption now in Florida of equal time sharing, and it's shared parental responsibility. If you guys don't want to do that, well, then let's look at the 20 factors in the statute to then try to get around. What do you guys want to do? Okay, let's run child support. Here's child support. Do you guys want to do it? Do you want to deviate? What do you want to do? But I give information, and then they go through. But here's the problem. If you don't know how to write a legal document, if you don't know how to read a statute, if you don't know what the law says, you can't do pro se mediation. It's not possible.
Yeah, you're right.
And there's a lot of people out there that want to, but can't. And so really this goes back to then, well, how do I build a business? My business is built on my knowledge, my expertise, and then my relationships with you and other attorneys.
Absolutely.
So this is not like, for me, it's not about, okay, I'm going to hang a shingle and they're just going to come to me. No, mine is performance and relationship built. Just like that attorney said, Scott, you use Matthew. We had worked together. We had a relationship, and that worked. Now I'll tell you a funny story. Years ago, there was an attorney in town, and I'm not even going to say whether it's a male or a female, but there's a very, very, very well-known attorney in town. And this attorney, I had always wanted to mediate for. I knew who this attorney was. Never, ever had a call from this attorney. And one day, I got a request from this attorney. And what was interesting was on the other side was pro se and out of state. So this attorney had said, fine, I'll try, right? And we got to settle. And I've worked with this attorney for years since. But what's funny is this attorney told me, Matthew, everybody in town was going, you've got to use Matthew. You've got to at least try him. You've got to try him. And this attorney said, I am not going to use him purely because everybody says I should.
Which is so stupid.
It's so stupid. I mean, it's so stupid. But guess what? This attorney finally did. And we're great friends. This attorney is phenomenal. We've mediated many cases. But this one attorney said, look, you know what? I'll try with pro se on the other side, not another attorney. I'll try him on this.
Yeah.
And we got it settled. And this attorney was like, okay, wow, he actually does know what he's talking about. And he's got good clients managing, pro se expectations or even her clients' expectations. And a lot of that goes back to, Scott, just me going through it myself, understanding it, then getting an education for it. And so what was interesting was the first year then that I actually worked as a family mediator, I actually worked in the courthouse. So that was good. They trained me on the software of how to use software to run child support. They gave me the basic forms to start learning. And I was working under the, it was almost sort of kind of like a paralegal that works under the direct supervision of the attorney. I was working sort of under the umbrella of the court with the protection of the director of the mediation, the dispute resolution center there at the courthouse. And what was interesting was I got a crash course because I ended up doing, so it was interesting, the first 3 months, and you'll know this is a huge number. The first 3 months that I worked at the courthouse as a contract mediator, I did 112 mediations in 3 months.
Wow.
It was, I was doing 3 to 5
Talk about a crash course.
day.
Yeah, that's a lot.
3 to 5 a day. And so then
mostly pro se.
No. Oh, no. This was almost all of it was attorney. Almost all of it was attorney. But then what was interesting was, remember, I told you in 2008, my first year doing family mediation, I did 15 cases, right? The next year, 148.
Wow.
And so one of the things that I've learned too with a lot of young attorneys is a lot of young attorneys, they'll go to law school, they get out and they'll be like, I'm going to open up my own practice. And, not knowing how to run a business, not knowing how to, not really knowing the law. And so I've seen a lot of attorneys through the years being a mediator that, they may have started their own firm, then they go and they work for a big firm, and then they go back out and open up their firm, and it's actually even better because they cut their teeth in a big firm. They learned a lot of the things because not everybody, your job is not just running a law firm. Like you've got employees, you've got other attorneys, you've got you're running a business, you've got marketing, you've got all the things that go along with it. It's not just, I'm going to just go be an attorney and represent clients.
Yeah, no, it's not like that at all.
And so what I did, because again, wanting to do it, but not, and then I use this term sort of loosely, not arrogantly. I didn't know what I didn't know, but I was scared that I didn't want to ruin people's lives. So I went a slower route going, instead of just opening up my own and, I'm here, I'm going to learn with a safety net and with direction and with supervision so that I could learn. So I started out with county civil in the courthouse. I then went to family in the courthouse. And then the next year I thought, the missing piece of family is dependency. So then I got certified first as a county mediator, then as a family mediator, then as a dependency mediator. What I found though was the family or the dependency mediators, that there's no private dependency mediation. It's all in the courthouse. And so
Can you just tell people what dependency is?
Yeah, so dependency mediation usually involves Department of Children and Family Services. Usually the kids are in foster. Usually somebody's in jail, either the mom or the dad.
Yeah.
And with dependency mediation, I found it's not mediation. It's facilitation. Because usually in a dependency mediation, you've got the mediator, me, and then you would have mom, you'd have dad, you'd have mom's attorney, you'd have dad's attorney. You'd probably have a guardian ad litem. You'd have the guardian ad litem attorney. You might have Department of Children and Family Services, and you'll have department's attorney. And a lot of it is these agencies are all together, and they haven't spoken like maybe DCF, Department of Children and Family Services, has given a case plan to one of the parents, but then the guardian ad litem hasn't actually gone out and done their investigation yet. And the guardian ad litem is the guardian of the case. They usually go out and they do the investigation, report back to the court, because the judge isn't going to go and visit the school and do an in-home visit and talk to the family and the doctors and the schools and the teachers. So the guardian ad litem does this. So you've got all these different agencies. And so a lot of it is like, oh, you're so-and-so. Okay, here's my card. Here's this. Okay, all right, you're the one with the case plan. It's more facilitating a conversation around the table, but there's nothing to settle. Like, it's facilitation of information, but there's no closure. It's just kicking the can down the road to the next thing. And so that's not private. You're not going to get a private dependency mediation.
No.
And so then
probably one of the only areas of family law that I don't practice, dependency and adoptions.
Yeah.
I think those are the two areas that we really don't touch.
Yeah. And so then that was in 2009, I got certified. Then in 2011 in Florida, they created a whole new, brand new certification for mediation for appellate. And so with the appellate mediation, they had rules in order to get done. So you had to have at least either family or dependency certification in order to get appellate certifications. You had to have higher levels. You couldn't just do county civil.
Yeah.
You had to have a higher level. So I was one of the first 50 people in the state to get certified doing appellate mediation. So I went and did the appellate training. So I've been appellate trained since 2011. Then in 2012.
Do you do many appellate cases, though?
No.
Do you do many appellate cases, appellate mediations? No, right?
Well,
That's probably pretty rare.
Yeah.
Do you have to? Because you don't have to go to mediation if there's an appellate case, right? I mean, I don't really do appellate work either.
Okay, so
but
the answer is I've done 2 and no. Okay.
Since 2011, right?
Okay, so
funny.
All right,
Why
so
even have it, right? It's but I kind of understand why you
all right,
have
and
it.
Scott, I've done 2, and it's March of 2024. I've done 2 in the past 6 months.
Oh, 2 in the past 6 months. I thought you meant 2 since 2011.
No, you're right. 2 since 2011, and they've been in the past 6 months.
That's so funny. Oh, that's so funny.
So now what they were family law cases that actually then went to the 4th DCA, which is the 4th District Appellate Court. Then the appellate court kicked it back to the family court, and the judge didn't want to deal with it and sent them to me. And so then they came back to me. So they were appellate cases, but they were based on. Now, I was their family mediator the first round. They didn't settle. They went to the judge. The judge made a mistake. It went to the appellate court. The appellate court sent it back to the judge. The judge goes, I don't want to deal with it. Go back to Matthew. And they came back to me.
Yeah.
But then in that case, Scott, we had both of their attorneys and 2 appellate attorneys. And so now we've got 4 attorneys with the parties and everybody, not just the appellate attorneys, but their regular attorneys. Everyone's arguing over the language from the appellate court. I'm going, oh my gosh, guys, really? Yeah. And so really with appellate law, it's actually pretty fun because with appellate law, there's already been a declared winner and loser, usually, right? But now, I mean, think of it like this. Apple sues Microsoft. Microsoft then sues Apple. Now, here's the problem. The 2 of them have to continue doing work together. it's going to go past this, whatever this little lawsuit is, it's going to have to go past that. So really it comes down to, do you want to spend a truckload of money or do you want to spend a boatload of money? You choose. And so a lot of that is just figuring out what is the issue. Let's see if we can figure out the issue because the relationship still needs to continue, right? That's generally appellate law. But in my situation, dealing with appellate law within the confines of family law, there wasn't a declared winner or loser. What happened is the family judge made a mistake. Then the appellate court said, yes, they made a mistake, sent it back to fix. And that judge goes, I'm not going to fix it. You guys fix it in mediation. And unfortunately, what happened is no one's a winner. Nobody's a winner because both of them have lost a lot of money in the meantime.
Yeah.
So then I got certified doing appellate. And then the next year, I then took a the trainer course and got certified as a trainer because I wanted to open up. I wanted to be one of the trainers for the family law certification. So I spent an entire year writing the entire curriculum for the 40-hour for the 40-hour trainer and sent that off to Tallahassee. The DRC, or the Dispute Resolution Center in Tallahassee, is awful, by the way. And I think a lot of it is sort of kind of just how the law is. They said, well, we reject your curriculum. I'm like, okay, what parts? Well, you need to figure that out.
Yeah.
What do you mean I need to figure out? Like, tell me which parts. Well, you need to look at the statute and figure it out. I'm like, why don't you just tell me and I'll fix it? Well, what it was, Scott, was the people that were sitting on the board, they were the existing trainers in the state of Florida, and they weren't certified. They weren't letting anybody come in because they were trying to corner the market.
Gotcha.
And so then I decided, well, you know what? I'm going to file a complaint with the ethics board.
Yeah.
So I filed a complaint. The problem is those same people sat on the ethics committee. And so do you think my complaint saw the light of day? No.
Of course not.
So at that point, I said, you know what? I'm so busy because at that point, I mean, we're now into 2012. And in 2012, I'm up to 191 mediations a year. The next year, I did 234. The next year, 279. The next year, 282. There's only 151 calendar work days. And I'm doing almost 300 mediations a year. I don't have time to teach.
Wow.
I'm too busy helping people and doing it.
Yeah.
So in the 17 years, I mean, as of February 29th, so 2 days ago, I've done 3,086 mediations and I've mediated for 10,643 hours of my life.
Holy crap. So how do you keep track of it? Do you have like a spreadsheet that you keep track of it with?
Yeah, annual spreadsheets. So
that's awesome.
So yeah, and recently, you know, I saw you up at the family law conference up
in Orlando.
And I actually ran into two judges up there and they were like, oh my gosh, thank you so much. We see your name all the time. You're settling everything, so we don't have to deal with it. And they asked me, they said, Matthew, what's your settlement rate? And I hate that question. I had a call one day, Scott, from an attorney. They said, is this Matthew Brickman with i-Mediate? I said, yes, it is. They said, what's your settlement rate? I said, what? They said, what is your settlement rate? I said, I don't understand your question. And they said, all right, Matthew, how many mediations do you do and how many do you settle? Because I will only use a mediator that has a 75% settlement rate or higher. And at that moment, I said, oh, I'm sorry, you have the wrong number. And they said, is this Matthew Brickman with i-Mediate? Yes, it is. Okay, so what do you mean I have the wrong number? I said, oh, you're not looking for a mediator. That's not my job. And they said, now, so of course I flipped the script. They said, well, what do you mean? I said, my job is to empower people and give them information, not get them to settle. If they choose to settle, that's their choice. Now I'm there to give them information, but they're in charge. I said, if you're asking me what my settlement rate is to figure out if you're going to use me, you're not looking for a mediator. You're looking for a manipulator, and you have the wrong number. Yeah. And they said, well, thank you very much. And I've never heard from them since, nor do I want to, because that's not my job. I've had people, Scott, I had an attorney once call and they said, hey, Matthew, we've got a really difficult case. We want to use you, but you really need to strong arm the other side. And I said, That's not going to happen because that's not my job. They said, yeah. But well, I mean, we're going to need you to really take control. I'm like, not my job. I said, my job is to empower people. We're going to look at options. We're going to talk about stuff, but my job's not to force an agreement. That's manipulation, not mediation.
Yeah.
So the two judges that I met up there, they said, Matthew, you know what your settlement rate is? I said, here we go again. I said, I actually don't. But my job is not to get people to settle. My job is to empower them. And the judges said, you're absolutely right. But we didn't know if you actually knew. I said, no, I don't.
Yeah.
But that night I went back to my hotel room and I was like, you know what? I have no idea. Let me see. Because again, I got spreadsheets on everything, right? So I did look, Scott. And so in 2023, I had 238 mediations. Now, here's the other thing, too, is as a mediator, there's a lot of times where things will impasse, but it'll settle before trial.
That's exactly what happened with one of the ones we did last year. We impassed in, I think, October and November. We used you, and it ended up settling, I think, in January. But a lot of it was attributed to you taking the time, showing that you're interested, listening to them, and then just making sure that they're going through the channels that they need to get the information that they need. And rather than just listening to the attorney and kind of like using what they have in their own head, to kind of like let them run wild, right, in terms of the case. I mean, a lot of times it's just giving them the information that they need to hear and then just making sure that they're just guided to where they need to go.
Yeah. And again, that's my job, is to give them information. So I did look, and last year, so of mediations that I mediated and they settled in mediation with me. So not things that I don't know, like maybe they continued and then finally settled, or they impassed and they settled later, but ones that actually settled with me, 61%.
Which is, I think,
which is cool.
Which is a very high number,
Yeah,
a very high number in and of itself, because I'll just, let everyone listening know. I mean, most mediations, to get a deal done at mediation, get an agreement written and signed, it's not easy. Yeah. It's not easy.
Yeah. And so what was interesting, Scott, I remember one of the, when I went out on my own, when I left the courthouse and started out on my own, I remember one of the first ones I did the mediation, and it did not settle. And it was about a week later, I was in Panera Bread, and I'm sitting there having lunch, and in walks the attorney from that mediation. And I felt bad. I didn't want to see him because I didn't settle his case. So I figured, well, I'm not going to look at him. And if I don't look at him and see him, he won't see me. Well, that's not how it works. He beelines right to me. He's like, hey, Mr. Brickman. I'm like, hi. Right. And he says, hey, great job on that mediation last week. I'm like, the one that didn't settle? He's like, no, it settled 2 days later. And I'm like, and I said, oh, really? He goes, yeah, great work. He goes, you know what? You got everybody thinking. And you know what? They ended up calling. We ended up negotiating. We ended up signing a deal 2 days later. And what I found, Scott, that day, which is exactly what you're talking about, a lot of times in mediation, I have found that mediation can be a springboard to settlement. Maybe they don't have all the information, or maybe they're not in the right headspace, or maybe they need to hear it from a neutral person, not from their advocate or their attorney that they've hired. Maybe they just need to come in. Maybe there's new options that nobody explored, or maybe now they understand where the other party is coming from. Maybe they thought that it was a different perspective. They now understand the other party's perspective, and that changes then their perspective. And so mediation can be there for a multitude of reasons. And there's lots of things to be found in mediation. As, my job is to guide that discussion. A lot of times, and I guess sort of, if you want a humorous analogy of what I am, I'm a tour guide. That's my job. Yeah. I'm a tour guide.
Yeah.
And why am I a tour guide? Well, because I've walked this path myself. I was in court for 12 years. I've gone down this path.
Yeah.
And so I made it to the other side. And, they always say, it's lonely at the top, right? It is. Mm-hmm. And when I made it through, and when I became a mediator and I was helping people, you know what? I felt like, okay, I reached the pinnacle. I made it through. Why do I need to be the only person that's figured this out? And so I was like, no, you know what? I want to help other people figure out what I have figured out. And so a lot of times how people try to move people is they either get behind them and try to push them into something, or they get in front of them and try to drag them into something. Mm-hmm. And as a mediator, I'm like, look, let me tell you a story. I have been through this. I have done this. And so why don't we link arms and let's walk this path together? And that's a different perspective that people are not accustomed to, especially going through a divorce or paternity action where things, they're going into the unknown.
Yeah.
And that also, like even hiring you, they're hiring an attorney that they hope understands, that they hope can hear them, listen to them, guide them, and get them to the other side. But they don't know. And there's a lot of hesitation. There's a lot of fear, a lot of concern. But then to get someone that's, no, I've actually lived it. I didn't just go to school and be like, oh, yeah, I'm just going to do this. I've lived it. And you know what? Let's explore options together. This is what I've learned. Take it or leave it. It's up to you. Here's the information. And I have found that, I wrote a book years ago. It's called You're Not the Only One. When I went through my 12-year battle, I thought that I was the only one who had ever done this. People used to say to me all the time, oh, yeah, Matthew. Oh, yeah. And I'm like, no, you don't understand. You don't understand. No, you don't understand. Right. What I've learned is as dysfunctional as my life was, 520 docket entries. My ex was nowhere near as bad as a lot of the people that you and I deal with every day. There's different degrees of dysfunction. And you know what? I've walked this path. One of the analogies that I give people is this. We're going to walk down a path. Think of it as just a dirt road. There's trees on both sides of this road. So we have to walk down this path. You can't deviate from the path. You have to go through this path. And as you look past your nose and you look down the path, it appears that there's holes all through the ground, right? Well, being that I have gone through this path, I know which holes you need to jump into to avoid obstacles and what pits you need to stay out of. Yeah. But since I've walked it, I know where the pits and I know where the holes are, and I know where you can dodge this and you're going to be okay to get out and recover and move forward, but do not go here. It's going to be very hard to get out of. And so that's why I say I'm a tour guide. I go up the mountain, I come down the mountain. I go up the mountain, I come down the mountain. I go up the mountain, I come down the mountain. Yeah. And so, you know what, to me, too,
so much.
You know what? I don't get burned out because I'm a tour guide. It's fun. I like helping people. It's my calling. It's not a job. I'm making an impact on future generations.
Totally. 100%. What would you say? Obviously, you just said it. You do, hundreds of mediations a year. What advice would you give someone that's going through a divorce or a paternity case right now, and they're about to enter mediation? What advice would you give them before entering mediation?
All right. So the first thing that I would say is go listen to my podcast, because I actually have an episode.
Perfect time to plug it.
Yeah, I know. So Scott, on my podcast, which is called Mediate This, I actually built it. It's actually set up progressive. So in the beginning, just like you build anything, you start with the foundation, then you put the walls, then you put the roof, then you put the windows, then you start decorating everything. So what I did when I first started with the podcast is we built it from the ground up, built it on foundation. So one of the first episodes is, how should you prepare for mediation? And then the next episode is, how do I prepare for mediation? Right? So, nice. So, I mean, if I was just going to sum up, like, what should somebody do in order to prepare for mediation? I think the two things that a couple of things I would say. First off, I think usually it's a good idea if the two parties can have a conversation first. I mean, how you resolve any conflict is the people in conflict need to try to figure it out amongst themselves. If they can't, then you engage a neutral. So your pastor, a therapist, a mediator, right? If that doesn't work, then fine. You hire someone to represent you, counsel, an attorney like you. And if that still doesn't work, then you know what? Surrender your decision-making authority to a higher power, a judge, and let them tell you what life is going to look like. Okay? So the first level of advice, or the first piece of advice, is try to have a conversation and figure it out amongst yourself. Now, here's what I tell people, though. You need to be very specific in your conversation, because this is the biggest pitfall that I see, Scott. You and I have a conversation about something, right? And you walk away going, wow, that was a great conversation that I had with Matthew. And I walk away going, Scott and I have an agreement, right? Do you not hear that a lot as an attorney?
I've heard that one before. 100%.
Yeah, and
then that person, thinking that they have an agreement, calls up me, says, "Oh, I have an agreement with my spouse. Can you write it up?" Sure. Yeah. Okay. You write it up, send it to the other side. The other side takes a couple of weeks to review it. All of a sudden, I get an email from an attorney. "Oh, I represent so and so, and we don't agree to your agreement." What do you mean? They told me they were in agreement. Yeah. You know, well, I see that many times.
And so I'll tell you, a lot of times with my pro se people, going back again to people representing themselves, I'm like, look, try to figure out as much as possible between the person, you know, your spouse or the other parent before you get to mediation. If you want to pay me hourly to have that discussion for the very first time, fine, that's your choice. But try to figure it out. But just make sure, clarify whether it's a conversation or an agreement. Because that is the biggest pitfall. That can cost thousands of dollars, if not tens of thousands of dollars, because one person, I mean, for example, just like you said, they call up and say, "Hey, Scott, we have an agreement." They pay you to then draft the whole agreement, get everything, get it to the other side. And then they're going, "We didn't agree to that. We just had a conversation about it." And so my advice to people, whether you have counsel or not, is try to figure it out between the person that you're having the dispute with, but be very clear between conversation and agreement. Very clear.
But I think, just to kind of fill in for people at home, I think it's smart for people to get educated even before going into that conversation, because a lot of times I find when I'm talking to just potential clients, they have no idea what they're entitled to under Florida law. Yeah. So at least go into that conversation and say, okay, let's try and resolve it amongst ourselves, but at least I'm armed with, here's what I'm entitled to.
Yeah. And Scott, that's the great thing about your podcast. And what I've tried to do with mine is I love your podcast because it's a lot like mine. It's not geared towards attorneys. It's geared towards the general public.
No, the actual people.
And so for the public to be able to get the information that you and I are telling them, that is their information that they're armed with prior to having those discussions. Like one of your previous episodes just recently was about alimony. And it was very, very good, because when you break down and explain to them, this is what Florida law says about alimony. Well, then when they have the conversation with their spouse about alimony, they're not going, we've been married for 25 years and I'm getting permanent alimony, going, it doesn't exist anymore as of July of 2023, right?
Yeah. Or I want half of your paycheck, which that's not a thing.
Exactly.
I mean, that's just not a thing. Now we have guidelines, not guidelines like child support guidelines, but we have, a structure. The law now is more structured in terms of how we're coming up with that overall number.
Exactly.
So you need to know that before you go into that conversation, or just have like an emotional response as to, hey, this is what I want, or this is what I'll pay. Yeah. No, that's not how it works.
I've actually had a number of attorneys. It's funny, Scott. I've had a number of attorneys that the client has come, consulted with them, retained them, and then the attorney says, go listen to Matthew's podcast before mediation.
It's awesome.
And like I said, years ago, I wrote a book called You're Not the Only One. Yeah. And that has actually been used for CLEs. It actually was approved for CLEs. Wow. And so people have used the book, and it's free on iTunes, and people have gone and gotten the book and used it as CLEs. But having your podcast or my podcast out there, helping the general public, that helps when they're having that conversation. The second thing I would tell them is, number one, when it comes to an attorney, you get what you pay for, and you have to pay to play. And so just because you get a board certified $550 an hour attorney does not mean that you're going to get somebody then a $300 an hour attorney. And here's the third piece. And I know you do this all the time because most attorneys do. When the clients come in to consult with you, it's not a one-way interview. They're not saying, oh, do I want to hire Scott Kalish as my attorney? Scott Kalish is going, do I want to take that crazy on for a case, right? It's a two-way street.
Yeah, for sure.
And so,
definitely.
And I mean, and I remember my attorney. I am an open book, which is literally like I have a book about my life. I have a podcast about my life. I'm an open book. What was interesting was when I had hired my attorney years ago, she would ask me a question and I'd start telling her information. She's like, whoa, Matthew, no. Too much information. I don't need that much information. Right. Yeah. And, I was like, I'd just like spill. She's like, no, don't tell me everything. I don't need all that. Right. But thank God that she didn't go, okay, you're a little emotional and I'm not taking that on.
Well, because you're very reasonable and very rational. It's when people want to share too much information and they're unreasonable, irrational, where you just can't handle them because you just don't have the time or the energy, right? You have a bunch of other people that you also have to service and help. And sometimes people are just, there's just too much baggage to assist, unfortunately, And it's just amazing, after practicing family law exclusively, it's amazing to see how much mental health really plays a role in family law cases, right? So if people got the mental health treatment that they needed, oh my God, it would make this process go a lot smoother. Because usually when we have, I wouldn't say usually, but I would say it's pretty common to have a case where one person is struggling with mental health issues. Yeah. And that just makes everything way more difficult for everybody.
Yeah. And one of the things, and I don't care where anybody falls on the political spectrum after 2020, right?
Yeah.
But everything that and when I say everything that the media reported on for the effects of the isolation, the schools shutting down, stay-at-home orders, all of that, we see it every single day. I saw a huge upkick in 2021 of child abuse, domestic violence, alcohol abuse, drug addiction. Yeah. I mean, all of it, especially after 2020 and ever after 2020. And I think a lot of it has to do too with the levels of access of information and social media, especially with young kids, depression, anxiety, suicide.
Yeah, see a lot of anxiety.
All of it, all of that since 2020, it just, and look, you can't say like, oh, well, we didn't know because we didn't have media like we do now. No, we're only talking 4 years ago. We had the media, but whatever happened, that whole sort of global reset in 2020, I saw every single effect that the news reported Scott, I was dealing with people that had never, ever touched an ounce of alcohol in their entire life. And after 2020, they ended up in rehab, domestic violence, addiction, because you know what? They were isolated. They were bored. They had nothing else to do. And all of a sudden, and these people are in mediation going, and especially like, for example, I mean, I remember one case where the mother-wife goes, he had never raised his voice. He was never going to be violent, but he absolutely beat me to a pulp when he started drinking. And then we got domestic violence. Then they've got no contact orders. He did it in front of the kids. Yeah. Now we're doing a supervised, safety-focused parenting plan.
It's amazing.
Yeah. And so, mental health has really affected what we do. And it's not just, and I'll tell you, I can't say every, but close to every single case, somebody is accusing the other party of narcissism. Right?
It's almost every day. So I do a lot of consults. So I'm the main person at the firm that does the consults. Okay. And I would say I have at least a couple a day, at least sometimes 4 a day. Right. Okay. And I would say at least once a day, someone's saying that, oh, my husband or wife is a narcissist. Okay. And a lot of times it could be true. I mean, listen, I represented someone that was an actual narcissist and the other side was saying that. And then during the case, I realized that they were. And I got off the case because I just started to look back and I saw the red flag. So it's definitely a real thing. Yeah. But, it's being thrown around a ton nowadays.
So here's the 3 things I I see thrown around all the time. Okay. Ever since being a mediator. Number one, I love you. That's so overused. Like, show me, don't just tell me. Show me love. Don't tell me love. Show me. Demonstrate it, right? The other thing is parental alienation. That term is thrown around. Oh, yeah, parental alienation, parental alienation. No, there's a lot of times it's not parental alienation, but that gets overused. And unfortunately, what happens is it turns into almost like the little boy that cried wolf. You say, I love you so many times, you don't really show it. You're like, I love you just falls on deaf ears. Parental alienation. Yeah. And now the new term is narcissism. Everyone's narcissistic. Everyone's narcissistic. And so, and it's funny. I'm always like, okay, open up your phone, go to your Photos app. All right, tell me how many photos you have on your phone. How many of those are selfies? Really? Who's the narcissist?
Right? That's funny.
Right? Like,
funny,
I've got 12,000 photos and 11,000 of them are selfies. Tell me who the narcissist is again.
That's funny.
Right?
No, it's so true.
But it's so true.
What would you say some of the biggest mistakes attorneys make during mediation? I mean, you've done so many of them. I'm sure you could name a few things.
So I think I remember many, many, many years ago in school, they said, look, the attorney really has two main jobs. When I was in law school, they said two main jobs. Number one, you have to manage your client's expectations. Give them the law, but manage their expectations. And number two, you've got to have client control. If you don't manage their expectations and you don't have client control, then it doesn't matter. You're on a runaway train. And potentially, if you don't manage their expectations and you don't have client control, you might be setting yourself up for a bar complaint. And then that is going to kill your business. And why did you even go to law school, spend all the money, become an attorney to start with? So focus on those two things. There's a lot of times where there is no client control and there are no management of expectations. Let me give you an example. I had a mediation the other day. Okay. And the husband's attorney did not manage the expectations. The husband had retirement accounts. The husband did not want to divide the retirement accounts.
The retirement accounts were clearly marital, I'm guessing.
All of them. Yeah, clearly marital, right? And so they tried to create a invisible number on an asset in order to try to justify him keeping everything.
What do you mean?
So what they tried to do was they said, look, we believe that the house is worth X.
Gotcha.
No, it's not. Oh, yes, it is. And therefore, since you're going to get that, and we'll give you the extra, well, then you're not entitled to this. And it's like, but that's not what it's worth. And so
just completely fabricated a number that just had no basis in reality. No basis in reality.
So the other side goes, we'll get it appraised. And I'm going to take half of the retirement accounts. It's real simple.
Yeah.
And the other side says, no, I'm not giving you the retirement accounts. And so I said, well, then get it appraised. Fine, we'll get it appraised. But I'm still not giving you the retirement accounts. I said, okay, so in what, now again, I can't tell the attorney, all right, you're not even giving good legal advice, right? I can't do that. And
it's such an unfortunate thing. You're probably biting your tongue sitting there watching it.
No, I'm not.
Because it's
no,
you're not.
No, I'm not. And
because you get to just click off at the end of the day and just
no. Yeah, but
what is it?
You know that I'm not just going to click off, but there's a way. There is a way, and this comes through experience. Okay, this is not learned. This is something that I've learned through experience of how to negotiate, how to help people. So I can't call the attorney out because number one, I can't call the attorney out. Number two, I am not about to have the client lose confidence in their counsel. Not about to do that because that's even if it's not good legal advice, at least that's the only sounding board they have. That also is not going to be good, because if that happens, guess what? They fire counsel, and now the other attorney has to deal with a pro se with unrealistic expectations. It's only going to cost their client even more money. So how do you deal with this? I just start asking exploratory questions. I just start going down a path going, okay, so what would a court do? What is the power that the court has? What is the statute? Let's pull up the statute. I go to chapter 61. I open it up. Let's look and see. Let's see date of marriage, date of filing. Okay, we get an appraisal. What do you owe on it? We divide it in half. Same thing then with the retirement accounts. So, all right, let's say I understand he wants to keep his retirement accounts. I hear that. I understand it. I don't have to agree with it, but I understand it.
Yeah.
And if they can't figure this out, and if it goes to a judge, what would the court do? What would the court do? Would a judge ignore an inflated value on a home so that he could keep his retirement account? Because here's the other problem. Yeah. We're talking about taxable income or taxable or tax affected monies versus non-tax affected monies. And, and it wasn't that he was giving her an unequal distribution of non-taxable dollars to keep that. That's different. No, he wasn't doing that. And so
he just didn't want to give anything.
And so by asking these questions, what would a court do? Let's look at the statute. I'm not undermining anybody's authority. I'm going.
No, it's you're using your questions to force the attorney to educate the client the way that they need to be educated.
Correct. Yeah. Correct. Now, here's the answer I got. So, what would a court do? Well, Matthew, he wants to keep 100% of his retirement. I said, okay, I understand. She wasn't going to. She wasn't going to educate her client. It was not going to happen.
Horrible.
Now, unfortunately, this is what I told the client. I said, okay, so remember in my opening statement, and Scott, as a mediator, it is very, 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 very important in the opening statement to lay the foundation, the ground rules, what everyone's role is, what my job, their job, your job, everyone's job. So I told the client, I said, remember in the beginning, in my opening, when I told you that my job is to give you information, I may tell you things you want to hear, and I may tell you things you don't want to hear. Remember that part? And he's like, yeah. I said, unfortunately, this is the part of my job that's a little difficult, because now I have to tell you things you don't want to hear. But here's what I'm not going to do. I am not going to not tell you something. You choose to go in front of the court. Something goes sideways, and then you're like, oh my gosh, why didn't somebody warn me? Why didn't somebody tell me that that was an option? I had no idea. I said, no. I'm telling you, because I'm looking right here at the statute, this is how it's going to go down. Now, you don't have to like it. You just need to understand it. And when, not if, when it happens, you'll remember this conversation and you'll remember me. But that's my job. And so, again, it's look, I'm not there to stir the pot. I'm there to try to help settle. No. But you know what? I'm there to give them the information that maybe they're not. Now, here's the problem. I have worked to date, like as of right now, we're sitting here recording this. In my 17 years, I have worked with 748 attorneys. It's a lot of attorneys, right? Oh, yeah. I will tell you that probably 98% of them are amazing human beings. Yeah. I run into amazing human beings in family court. Family law attorneys are not the poster children of what people hate about attorneys. They're sharks. They're awful. They're just going to take your money and leave you. Not family attorneys. Most of them are very good, decent human beings. You will get those in civil and ambulance chasers and personal injury and stuff like that, but not in family. But there are a few in family, unfortunately, that, and this is part of the whole interview process for when the people are interviewing the attorney. It's important to Get online, read reviews. It's important to talk to a couple of different attorneys and maybe even ask them about who you consulted with, because unfortunately, there are a couple of attorneys that I've worked with through the years. The number one is a mediator. I refuse to work with them ever again. I'm not interested in working with them because they purely use me in the process to get their ticket so they can try this and go to an adversarial arena. They're not interested in settlement. They've never been interested in settlement. They don't care about managing their clients' expectations, and what they
don't care about the client. They don't care about the client. They really don't.
So many of them will do similar to what this person did. And what they'll do is they'll take it all the way to trial. And unfortunately, what's going to happen is a judge is going to rule. And you know what? They're going to turn to their client and go, oh, well, the judge ruled, sorry, we lost. And they are out, whatever all the monies they paid, because they had unrealistic expectations going into it. That's just one of the many facets of the job that not only do I need to understand the dynamics of personalities that I'm dealing with, I have to understand who the attorneys are. I have to understand what the legal issues are. But then sometimes we're dealing with unrealistic expectations and managing those. And, I had a mediation the other day where the mother did not want to do equal time sharing whatsoever under any circumstance. Well, look, I told you, I'm not going to push somebody into something, and I'm not going to pull them either. So I said, okay, you know what? Not a problem. Let's look at what you need to do, because there is an out for you. Do not lose hope. There's an out for you, but let's look at what you're facing. So we open up the statute, we go through the 20 factors. And then, Scott, and I keep things on my computer for when I need stuff.
Sure.
And I have a final judgment from a judge who made written specific findings on all 20 factors of what it actually looks like. And if we need to, I will pull it up and I'll say, this is what a judge actually was going to have to do. Look at what is now public record for what this particular judge.
For non-equal time sharing.
Correct.
Or equal time sharing.
Yeah. To try to overcome when they don't want to do equal, then fine. You just go to the statute, you go through the 20. Yeah. And so I've got a final judgment where a judge actually had to make the 20 written specific findings. It is scathing on both parents, and it's public record now. And then I say to the attorney, all right, so how long until you get in front of a judge, and how much are we looking at? How much is she going to have to pay for a potential opportunity? That doesn't mean it's a slam dunk. It's still an opportunity, but what's it going to be? And so then at that point, that particular attorney, good client control, said, look, we've had this conversation. Now, Matthew's having it with us again. Except actually, Matthew's showing you stuff that I didn't even have. Yeah. So this is the timeline. This is the money. This is what we're looking at. And I turned and I then redirected. I said, look, you don't have to settle on anything today. You can think about it. You can come back. Like, you're not going to be in front of the judge anytime soon. The choice is yours. Like, I'm there to empower them to make a decision. I said, look, if you can't live with this agreement, I'm not even giving you something to sign, because you're not calling me tomorrow going, Matthew, what in the world did you get me into? Or calling Scott and going, Scott, what did you allow me to get? No, we're not dealing with that. You need to look at an agreement before you sign it and say, can I live with it? Because if you can, well, then I'll let you sign it. And if you can't, I'm not even giving you an agreement. Because again, that goes back to, that's manipulation, not mediation. If somebody can talk you into it, somebody else can talk you out of it. You need to subscribe to it on your own. And that would be another tip that I would tell people. Do not come to mediation. It's so funny. There's an attorney in town. I love him. Do not come to mediation going, oh, I just want to be fair. I just want a fair outcome. It just needs to be fair. This attorney says a fair is where you get a fried Twinkie, not in mediation. And what I tell people is I say, this is not about fairness. In fact, the family court is not about fair or equal. It's a court of equity, which is a sort of a balance of fair and equal, but it's not fair or equal. And I said, that's why you're here in front of me today, is because it's about creating something you can live with. Don't look at an agreement and say, is it good or is it bad? Is it right or is it wrong? Is it fair or is it unfair? Because those are perspectives. I said, look,
Totally.
what I know now about with the knowledge that I have 20 years later after I got divorced, there's no way I would have signed my divorce papers the way they were. Knowing what I know now,
Really?
there's no way. Scott, I've had people as a mediator at the end going, Matthew, you'd sign this. This was a good agreement, right? And I'm going, no, I wouldn't sign it. And they're like, what? Well, I signed it. And I'm like, look, hold on. I said, look, there's not an agreement out there, including my own, that I would ever sign. I have never seen a perfect agreement that I would sign. Why?
There's never such.
I said, why? I said, you know what? I wouldn't sign your agreement because you know what? You signed up for this. I don't even care about that. That's not a hill that I'm willing to die on. You gave that away. Yeah. That's important to me. I said, look, that's why mediation is so amazing, because you can create whatever you want based on your own belief systems and your own family and your jobs. You get to create, opposed to going to a court and a judge rubber stamp a general plan and going, Scott, I know you put on a good case for me, but the judge didn't do anything that you said. And you're like, they have judicial discretion. And so I tell people in mediation, in my opening, and I would even tell people before, do not come to mediation looking for fair or equal or just or right or wrong or moral or immoral. You need to just look into agreement and say, can I live with it?
Can I live with this? Yeah.
If you can, then sign it. And if not, then a judge will dictate to you what your life is going to look like. You don't need to get upset and bent out of shape. If you don't want to take control, a judge will be there to do it. And here's the other thing, Scott. One of the things that I've really noticed since last year, because as you know, last July when they changed alimony, time sharing, the paternity statute, they got rid of the substantial circumstance for modification. I mean, the legislature turned family law upside down, inside out on its head. And I think they did mostly a phenomenal job of leveling the playing field. Okay. But here's one of the things I've been saying for the longest time, especially to my pro se people. A divorce or paternity action, very, very easy. Very easy. Time sharing, rebuttable presumption of 50-50. Child support based off of time sharing and your income. Alimony, need and ability. If so, we got a calculator. Equitable distribution, 50%. Like, it's not rocket science. This is really easy. You know what makes this job difficult?
What's that?
People. People make this job difficult. This is not hard. The law, and that's what I think people need to understand is you go in front of a judge, it's really easy. Equitable distribution, it is what it is. Time sharing is what it is. Child support is what it is. Alimony is what it is. If you don't like it, as long as the judge didn't violate public policy, they can do whatever they want. And be careful, because a lot of people, their arguments are moral in the court. I mean, really, you want a judge imposing his or her own morality or viewpoints or values on you?
I would say, along with moral, it's also emotional. I mean, how many times have you heard people say things just out of pure emotion, out of just feelings? Like I want this because I feel that it's right. What do you mean? We have a statute for that, 61075, equitable distribution. What do you mean, your retirement? I know, but I went to work and I worked every day and I saved for my retirement. Yeah, but that doesn't matter.
Yeah. I had I had a mediation recently where it was a paternity action. Okay. So, and that means they were never married. So it should be time sharing child support, but they bought a house together and they furnished the house together. And so then the mom ended up leaving. And her attorney included in the answer and counter petition a partition action. And they're arguing over the house. And they can't figure out the house. And I actually said, look, that we're even having this discussion is a gift, because actually that's not for the family court. You're not married. This is for the civil court. You need to open up a separate case, hire attorneys, and go into a civil court to deal with your house. All we're dealing with is time sharing and child support. But that we're even having this conversation is a gift. But here's the deal.
Yeah.
Here's the deal. You chose to play family without the protection of the family court. And there are different rules.
Yeah.
And I'm sorry that was your choice, but here's what we're now looking. This is, and I said, look, now the answer is not going to be different. You go to civil court, it's still real estate law. Your tenants in common.
Tenants in common. Yeah.
Like it's the same outcome, except we've included it here, but sorry, you're not getting half of the contents of the home. You're not getting reimbursed because this is not a marriage. You guys can duke it out on what do you want to do with the contents of the home or what you want to, but you know, how the house is being done. And so they were able, the father wanted to assume the mortgage. He was able to assume it, not refinance it. And she was bent out of shape on a moral standpoint that he was able to keep the same percentage rate. And she was going to have to go out and get a new place under the new inflated numbers.
Yeah.
But you know what?
Yeah. Yeah.
What do you want me to do? Like,
yeah, no, I know it's not right.
Yeah.
Right. It's not morally right.
Yeah.
But like from a legal perspective, there's no issue with it.
And going back, Scott, going back to the one with the retirement accounts, they actually said to me, they said, Matthew, the other party, they're not negotiating in good faith. And I said, what do you mean they're not negotiating in good faith? They're not even negotiating. They're saying this is what it is and we're not negotiating. I said, well, the reason for that is because you're negotiating based on what you want and they're negotiating based on what the law says. So they're willing to negotiate, but they're not negotiating against themselves when the law gives them what they're asking for. And Scott, you know what? And here's the other thing. You know how much we're talking?
How much?
$400,000. We're not talking 20 grand, 30 grand. We're talking almost $500,000 trying to inflate so they can keep and not do equitable distribution. Look, they're better off taking that in front of a judge. They're going to spend less than $400,000 on their attorney. You know, sometimes we have that. Sometimes we have that conversation going, Scott, how much is it going to cost? Well, you know, they're looking for 20 grand, but they're going to spend 30 just trying to get 20. How are they doing? Okay, fine, we're going to settle. Look, for $400,000, you're not getting anywhere close with attorney's fees to then get what the law gives you.
Yeah, it's crazy. It's crazy. This has been a tremendous episode. I so much appreciate you coming on and sharing your wealth of information and your knowledge. If people are interested in getting in touch with you, how can they do that?
I'm really easy to find. Google, I'm all over the place. Marketing is really good. So, I mean, I'm easy. It's either the website, i-Mediation.com. They can go to iTunes and find my book. It's called You're Not the Only One. You can go to any podcast distributor, and the podcast is Mediate This. I try to keep everything pretty simple.
Awesome.
But and then from there, then, you know, you can get phone numbers and email, and, you know, if you want to just Google Matthew Brickman, that's easy enough. I'm sure you probably got good marketing like that too, right, Scott? Like Scott Kalish?
I do. You can find me on the podcast platforms on Google, Facebook, I think, you know, so we're pretty easy to find. Again, thank you so much for coming on, and definitely have to have you on again. I'll have to talk about something else next time.
Sounds great, Scott. Thanks for having me.
All right. Take care.
Thanks for listening to the Florida Divorce Podcast. To learn the 10 secrets behind every successful divorce, visit floridadivorcepodcast.com. If you'd like Scott's help in your divorce case, go to kjlawfla.com.